Welcome, everyone. While we wait for more participants to flow into the platform, I'll take care of a few housekeeping items. On screen is the ARIS content disclaimer. Also, the webinar will be recorded and available on the website in the next day or so at arisinfo.com. There will be time dedicated for Q&A after the presentation. Please enter any questions you have in the Q&A section of the platform rather than in the chat section, as we may not see them there. My name is Scott Davis. I am Senior Vice President, Industry Engagement for ARIS and the host for today's webinar. Today, we'll be discussing some of the unique challenges, liability, and transaction considerations related to dry cleaning sites and adjacent sites. We are truly fortunate to have Michael Marcon and Larry Schnapf with us today. For over 25 years, Mike has been a principal with InControl Technologies, helping clients navigate the complex world of environmental regulations and site restorations. Mike has vast experience in assisting dry cleaners and property owners who have historical or current dry cleaning plans address the environmental contamination associated with historical waste management activities. Also joining us today is Larry Schnapf, an environmental attorney based in New York City with 40 years of national environmental transactional experience. He has chaired numerous New York State Environmental Law Association committees and has served on several ASTM task groups. Larry is an adjunct professor of environmental law at New York Law School. For their full bios, please visit the webinars page at arisinfo.com. So to start things off, it gives me great pleasure to turn it over to you, Mike.
Oh, thank you, Scott. And thank you for all the people that are joining us today. If this is phase 2 or part 2 of a presentation we made earlier regarding dry cleaners. And today's session is discussing the dirtier side of the dry cleaner, really looking into liabilities associated with properties that had dry cleaners or historically operated dry cleaners on the property. If you joined us for the last dry cleaner presentation, which the link is here on the slide, if you weren't there, you can go and get a copy of it. We talked about the different types of dry cleaners, the different types of dry cleaning equipment, and potential environmental issues associated with the historical dry cleaning equipment. And we got to remember that dry cleaners have been around for a very long time. The first recorded dry cleaner was back in the record from Pompeii, when we heard that they used various compounds to dry clean clothes. But the modern dry cleaners, the cleaners that we're talking about today, we went through sort of in detail the various equipment, the generations of the equipment, the sources and waste that are generated by dry cleaners that become environmental concerns, went through sort of the investigation issues and some remediation. And we finished up with a discussion regarding emerging issues like the PFAS issue with in the materials that are showing up in a lot of the effluent discharges and waters coming from the dry cleaners, not only from the dry cleaning process, but from the wet cleaning process. And so the one thing we left out of that original presentation was a detailed discussion of the liabilities surrounding dry cleaners, mainly associated with transactions and due diligence, which many of the participants today are involved with, phase 1s and property transfers. And so in the words of Paul Harvey, we're now going to listen to the rest of the story and really delve into the liability and the transactional considerations that a person needs to consider when buying and selling properties that had historical or even current dry cleaners. And with that, I'm going to turn it over to Larry. Larry is an attorney and is going to talk about the legal side of everything we talked about the last time. Larry, thank you.
Okay, thanks, Mike. And we're going to talk today about dry cleaners and also laundries. So the fact that something's identified as a laundry doesn't mean that it doesn't pose a risk, the same kinds of risk as a dry cleaner. In the last go around for ASTM, the last revisions, EPA had told our task group that dry cleaners were now the #1 source of new Superfund sites in the country. That's largely because of the new vapor pathway, the subsurface vapor intrusion pathway, that now allows EPA to list sites based on vapors and not just groundwater. And dry cleaners, I think, probably are the #1 source of contention among consultants as to whether they represent RECs or not, and between lawyers and consultants and their clients. So if there's one issue that needs to be, I think, fleshed out, it is probably the potential liability of dry cleaners, because it's not only just the liability of the client, but also the liability of the consultant. Because if the consultant fails to identify a dry cleaner as a REC, and it turns out it is a REC and there's contamination, one of the first targets of whether it's the property owner or the bank who hired the consultant is going to be the consultant. So what we're going to talk about today is both the statutory liability, some common law liabilities, and we'll do some couple of case studies, and then take your questions. So let me take over the presentation here. So just to put the context of dry cleaners in perspective, there's been a number of studies dating back to '92, but the Coalition of Dry Cleaners, which is the remedial programs, that's a state organization. The number of states that have dry cleaner programs, it's funded by EPA. They've done 2 studies, and their studies have shown that at least 75% of dry cleaners have had a release that's impacted soil or groundwater. So that's a pretty high number. And as I mentioned to you that, dry cleaners are not a leading cause of new federal Superfund listings. In New York, we have over 200 sites, dry cleaner sites, that are on the state Superfund list. And because of the nature of the way the contamination gets into the environment, dry cleaners, which are, when you look at them, they're kind of small operations, but their size, they have a disproportionate amount of waste they have generated historically. And they tend to be connected to the sewers. And that results typically in long plumes, or can result in long plumes of contaminated groundwater. And I'll show you a couple maps shortly as an example. So let me just make sure I didn't skip a slide here. Okay. We're going to go over the various correct statutory and common law liabilities, but when I'm talking about RCRA, I want to focus, there's a whole bunch of remedial programs under RCRA that a dry cleaner can fall under. But the thing that's important for a consultant to recognize is, and I've had this problem on a number of cases where they have a dry cleaner site and they then do sampling, and they're trying to determine whether it's whether the contamination, the contaminated soil has to be handled as a hazardous waste or not. And they typically will do a T-clip test, a characteristic waste test. But in fact, the dry cleaners are going to be a listed waste. And I've had situations where the consultant has missed that. They've determined that the waste is a characteristic waste, that it's not. They do the T-clip test, and then the soil does not flunk the test, and so they send off the soil to a normal landfill, and it turns out that it's a listed waste, and now there's a big fine that's been assessed against the generator, who's usually the property owner, and now they're looking around to blame somebody for the fine they had to pay. And I've had clients fined up to $1 million with obviously high volume But it's just important to remember that waste generated by a dry cleaner is going to be listed. I believe, Mike, it's an F waste. Is that correct?
That's correct, Larry.
Okay. And now the other thing that we're seeing is now that we have the vapor pathway and now the vapor intrusion has become a hot topic, there's a number of situations where EPA and the states could, but principally EPA can do a second look at the site and determine that additional work has to be done. So even if the site has been cleaned up and it's been closed, you know, there are 5-year reviews, and there's plenty of opportunities that EPA is taking a look at sites that were not evaluated in the past for the vapor pathway and re-looking at those sites. And the fact that we have vapor intrusion now is such a big issue. One of the things we oftentimes come across in due diligence is the consultant now identifies the dry cleaner as a problem because of the vapor issue. And then the client says, well, I had this site, you know, I got a phase 1 from 10 years ago. They didn't identify this as a problem, as a wreck. Well, you have to explain, you know, that things have changed, that we now, you know, the assumptions that we were using in the old days about the vapor pathway have changed. So that's important to know. And then we have state remedial programs also will be addressing dry cleaners, typically brownfields. And then we have the old longstanding common law liability, which interestingly, the statutes that were passed in the 70s were passed because the common law was not really sufficient to deal with the complications of environmental contamination. And now the common law has come back to plug the gaps where the statutes have. So let me go to the next slide. And there's some really difficulties when it comes to assessing the risk of dry cleaners, because we just mentioned that you have to reevaluate prior diligence. And a lot of times the description of the dry cleaners from the past are not very clear. You know, we don't know if they used secondary containment, if they had a solvent grade, grade flooring on, you know, to protect the floor from spills. A big issue that we're having is also the limited nature of the dry cleaner funds. So number of states have dry cleaner funds where they rank the sites according to a priority list. And then the site is enrolled in the program, and the state will fund the investigation and the cleanup. And there's been a misperception about a lot of these funds. They typically, they're getting better now, but they've typically ranked sites according to impacts to drinking water. And they haven't focused as much on the vapor pathway. And so the fact that a site might have a low ranking, which means it's going to take a couple years to get funding to do the investigation and cleanup, does not mean that there is no risk posed by the site. You know, and dry cleaners are oftentimes very close to residential properties because of they're located where they are because they're convenient to customers. And the concern there is, what if you could have a plume that is not used for drinking water, so the ranking is low, but that contaminated plume could be migrating, you know, offsite below residential properties. Another problem we have with offsite issues is when you're trying to assess whether there's an offsite impact or not. A lot of people, believe it or not, are declining access to their homes, even though you would think they'd be concerned about health issues and particularly, you know, their children being exposed. But many times they're also worried about the value of their home. And somehow there's this perception that, you know, if I don't have any sampling in my home, but my neighbor has sampling and they have a problem, it's not going to affect my property value. So that's another problem. And then the classic question comes, do I do a phase 2 after the site's been identified, the dry clean's been identified as a wreck, or do I just get insurance? And insurance, is available for what we call fortuities, for things that are not known. Sometimes you get them known, but usually for the most part, it's for unknown conditions. And once you do sampling and find there's a problem, then you no longer can get insurance. And so sometimes banks will, instead of doing sampling, will just get an insurance policy to cover the offsite potential tort liability. So another problem we have is, particularly with vapor intrusion, is there's evolving standards. They vary from state to state. The pathway is very complicated. We have situations where you think there'd be a completed pathway and there isn't. Other times you don't think there'd be a completed pathway and there is. And again, the idea of sampling is going to be a conversation with your client. And some clients are going to have a lot of risk tolerance and are just going to want to kind of just put their head in the sand and pretend there's no problem. Others are going to be pretty, pretty alert and be willing to do further investigation. And of course, there's all kinds of uncertainty with the remedy. You might have a property now that is a commercial property where a dry cleaner is, but what happens 3 years from now when someone now wants to redevelop that site as a residential development? They look at a phase 1 that was done a couple of years ago, and if there was a risk-based approach to it, and like in California, we can go 10 to the -6 to 10 to the -4, the assumptions that may have been made with that phase 1 may no longer be applicable. So the change in use and also the risk of construction when there's exposure to workers is a changing is an issue that has to be addressed. And then there's the mitigation handoff. So oftentimes, particularly with residential properties, a developer may put up a building and then the building management is handed off to a co-op or condo association or a property manager, and they may not be aware of why these fans are operating, and they may not be very careful about maintenance. So there's all kinds of issues that when you're reviewing a site, you have to see, look at the particular issues for that site. Let me try to go to the next slide here. Why is this not working? There we go. Okay. So that's kind of the background of the complications for dry cleaners. And, dry cleaners oftentimes change ownership. So they oftentimes have 3 or 5 year, I think the average dry cleaner is 5 years, the operator. And if you're doing Sanborns or other historical researches and you're only doing them every 10 years, you might miss a couple of dry cleaner operations. And oftentimes they're not really clear as to what was there. It's hard to know if it was a drop off or whether actually on-site operations were conducted. If it's a laundry, was it truly a laundry, or was it one of those laundries that used to have the coin operated machines that leaked? So I just want to briefly go over the Superfund law, because that's the reason we're all doing due diligence now. That law imposed strict and joint liability on 4 classes of responsible parties. And those, the main ones of interest to this group would be owners and operators. Owners are the ones that either hold title or have the equivalent of title, like say long-term leases. Operators are like the tenants. And strict liability means it's liability without fault. So if you own a property now and it was contaminated in the past, by virtue of your status as a property owner, you could become liable unless you can qualify for one of the defenses. And this liability is predicated on releases of hazardous substances from a facility. Now, there's an exclusion for releases solely within the workplace. That's a relic of when the original version of CERCLA was going to have a personal liability, personal damage claim availability, but that was not part of the final law. But this language was inadvertently kept in the statute. And for a time, people thought that, well, if there's a vapor intrusion in a commercial building, this exclusion would operate to make that there would be no liability, and that the liability would really be addressed by OSHA. And we'll show you later on why that's a bad idea anyway. But it's now clear that, releases are very broadly applied, and it's intended to be gaseous releases as well as releases of solid or liquids. The facilities is anywhere where the hazardous substances come to rest. Now, in some state laws, it's usually the source area is the facility. Remember, it's a release of a hazardous substance from a facility. So the dry cleaner the shopping center where the dry cleaner is going to be the facility. And under CERCLA, if the contamination migrates off-site, that could include those off-site properties as well. And then once the parties, once the elements of CERCLA liability have been established, EPA can issue a unilateral order, which is an order just issued that requires a party to comply with this order. And if they don't comply, they can be liable for treble damages, 3 times the cleanup costs. Obviously, if the agency or a private party incur costs, they can then go seek cost recovery against the responsible party. So in this case, not only could EPA go after, say, the dry cleaner, but even the landlord might be able to go after the dry cleaner, or the neighboring party, if their property is contaminated, can go after both the landlord as owner and the dry cleaner as the operator. So again, just who are the liable parties? So it's interesting. There's been a couple of cases where not only has the property owner, the person that has the fee, been sued, but there have been a line of cases where they actually tried to go after the manufacturers of the equipment, the dry cleaner equipment. Mike has had some interesting experience with that, and I'm sure he can share those issues. The stormwater and sewer lines underneath the building are going to be owned generally by the property owner, but once they get onto the street, they're owned by the municipality. And so there have been lots of lawsuits filed against municipalities, particularly in California, saying that since they own the stormwater lines and the contamination has leaked from the stormwater pipes, they should be liable as well. Clearly, operators are tenants, and then generators are entities that arrange for disposal of hazardous waste, and the franchisors, as well as equipment manufacturers, there's also been claims brought against them under this generator theory as well. So although the liability is strict, there is an opportunity to assert defenses, which is where due diligence comes in. So the third party defense provides that if the contamination is solely the result of a third party with whom the particular defendant has no contractual, indirect or direct contractual relationship, and they take precautions, exercise due care and take precautions against the acts or omissions of third parties, they could assert this defense. Now, this defense has been largely unavailable in most of the country because of the contractual relationship language. For example, a landlord has a lease with the tenant, and that would be a contractual relationship. Now, in California and New York, the courts have actually looked at the purpose of that contractual relationship. And if obviously when you're renting a space to a dry cleaner, the purpose of that contract, that lease, is not to dump PCE into the soil or groundwater, it's to run a business. So, and the innocent purchaser defense was enacted to solve the problem of the contractual relationship. But the due care element is just as important. We had a case in New York many, many years ago where a landlord was sued by the state, and the landlord had purchased the property from a tenant, the seller had the relationship with the dry cleaner. And as soon as the landlord found out about the contamination, they implemented measures. They put a fence up around the dry cleaner. They put signs, don't drink the groundwater. And the court found them not liable because they had exercised the due care requirement. So because the third party defense was so unavailable, in 1986, Congress passed the innocent landowner defense, which said that if the purchaser owner had no knowledge or had no reason to know that there was contamination, and then they exercised due care, they would not be liable as a owner or operator of the property. Well, the problem with that was you had no reason to know or need to know. And they also had to do that after doing an appropriate inquiry. And that's where the due diligence requirements came in. So because of the need to have knowledge, no knowledge, for most brownfield sites, for example, they're brownfields because there's a suspicion that there's contamination. That defense wasn't available. So in 2002, the brownfield amendments were passed that now provided for a bona fide prospective purchaser defense, which means you can knowingly buy contaminated property, so long as you exercise appropriate care afterwards, and that pre-acquisition you did your appropriate inquiry and you have no corporate relationship with the responsible party, and that all disposals took place before you take title. So when ASTM adopts versions of all of its phase 1 standard, it gets EPA to recognize the standard as an equivalent or a way of satisfying the all appropriate inquiry rule. And in the preamble to when EPA recognized the 2013 version, the preamble, which is the introductory language to the rulemaking, had some specific language about vapors, and it was basically saying that vapors were already a pathway that had to be considered when identifying whether there's wrecks at a site or not. So basically EPA was saying in 2013, if you had not been flagging vapor intrusion as a wreck, the consultants could be liable, as well as their clients. I'll let you read this in more detail, but I just wanted to know that EPA specifically said in 2013 that in their view, the vapor pathway had already been part of the all appropriate inquiry responsibility. So again, ASTM, the phase 1 standard, is the way it works out is basically it's the how. So the what is all appropriate inquiry. What is all appropriate inquiry? The EPA rule describes what you have to do. ASTM you can view as how do you do it? So all appropriate inquiry just requires there to be due diligence that'll indicate whether there's a release or threatened release of a hazardous substance. And now it's clear that vapors are part of the definition of a circular release. And I already mentioned that the circular facility is anywhere where the contamination is located. So all appropriate inquiry does apply also to the vapor portion of the pathway, and it applies to all migration pathways as well. And because the facility is not just the target, may not just be the target property, it can apply to offsite as well. But just wanted you to kind of get a flavor for and that's why we, as part of ASTM, we do our radius search. So as long as you do a proper radius search, you will be falling within the scope of the all appropriate inquiry rule. And the last two changes to the ASTM included the definition of, we refined the definition of migration so that it refers to movement of hazardous substances. And the legal appendix discusses, the interplay of indoor air. We have VEX now under the 2600 standard, the guide. So these are all just another examples of, is there, and again, remember, as a consultant, you're not being required to say for sure there's something there. It's a question of, is it likely that there's a release? So when a lawyer says to you, what's the proof that there's a release? Well, it's about whether there's a likelihood of a release. It's not absolute certainty. It isn't like beyond a reasonable doubt, right? It's not that high a standard. Is it likely? Likely is sort of like more often than not. It's a lower standard of proof. And it's based on your not only site factors, but your professional experience. I just already mentioned there's different authorities under RCRA to address dry cleaner contamination. Section 7002 has been used a lot. That's the citizen suit provision of RCRA. And that says that any person that is contributing in any way to the past handling, disposal, releasing, leaking of hazardous waste or solid waste may be liable, provided that that contamination is posing an imminent substantial endangerment. That phrase is interpreted differently across the country, but 7002 has been used a lot, particularly with gasoline stations because of the petroleum exclusion under CERCLA, but it's our favorite remedy of plaintiffs. In fact, there are companies that go into business their business plan is to buy contaminated property and then file 7002 actions, because you get injunctive relief. You can get orders from the court ordering someone to clean up the site. We can spend a whole day on 7002, but just want you to know it's there. But again, the key thing about RCRA is the listed versus characteristic waste. Make sure that it's an F waste. Make sure that you do the listed waste evaluation and handle that waste properly. Common law is the old-fashioned law that's evolved over time. So you've all heard of negligence. Negligence is where someone has a duty and they fail to act as a reasonable person in carrying out that duty, and that failure to comply with that duty causes harm to a plaintiff. Trespass is a physical interference with another person's property. And so think about particles of contamination going onto your property. That could be a trespass. Nuisance is the unreasonable interference. It has to be substantial and it's unreasonable with your property. You don't actually have to have a physical interference. You can think about if you have an animal rendering plant next door to your home, the odors by themselves will be a nuisance, prevent you from going outside. So nuisance is also a common claim that's used either against dry cleaners so essentially what we do in these lawsuits is we file a statutory claim and then we complement it with a bunch of common law claims as well. Strict liability, I mentioned. A misrepresentation can happen between contracting parties where one person, you don't have a duty. When you have commercial property, most deals are caveat emptor, buyer beware. So the seller doesn't have to disclose information about environmental conditions generally. There's some nuances, but this is not the platform for this. But when you do speak, if you choose to speak, you must speak accurately. And so oftentimes sellers will make representations. There have been owners who have actually sued banks saying that, well, when you approved my phase one, you said that the property was acceptable, which is not what the bank is saying. And then we have other types of non-disclosure. And of course, we have professional malpractice where consultants can either be held liable for breach of contract or for professional negligence. And we can talk about that later if you'd like. And then some states have disclosure laws, particularly residential properties. The scope of those laws depends state by state. So here's a couple of examples of plumes I thought you might, just to illustrate the problem. This one is from Las Vegas, and there was a dry cleaner that spilled. There was a spill at the dry cleaner, and the plume went from the dry cleaner, which is at the right, all the way across a major highway underneath the shopping center, and it impacted a bunch of residential high-end properties. Interestingly, the defendants tried to argue that there was no circle liability here because the only groundwater that was impacted was solely limited to Las Vegas, I guess under the theory that contamination that occurs in Las Vegas stays there. The district court wanted to hold in favor. The district court judge was very conservative, and he did not see why there was any federal liability here. Where's the role of the federal government here when it's purely intrastate, intracity? But he realized that if he ruled that way, the Ninth Circuit would have overruled him. So he ended up ruling in favor of the plaintiffs. But this was one example. This is the White Swan cleaner site in Seagirt, New Jersey. The plume is, as you can see, the dry cleaner is on the left, and this plume went over a mile to the Atlantic Ocean. And the fun backstory to this, and all you consultants that work for banks will enjoy this story. There was a dry cleaner there were two dry cleaners actually, but they were served by septic tanks. And then at some point, one of them became a bank branch, and the bank that owned that branch merged with another bank. And during this acquisition, the other merging entity decided not to do any diligence on any of the branch offices. So now the bank became the owner of a branch office that was the source of contamination that had migrated all the way to the Atlantic Ocean, contaminated the drinking water supply. And the bank actually ended up having to pay some money for the Superfund site. This is also a case where they had almost 50% of decliners, but this was a major plume as well. And this is the Bozeman solvent site plume. Now, this was a half a bucket of perc that was spilled. Someone kicked it over, went into the sewer system, but the sewer system, the pipes were connected with some sort of asphalt-based material. And so apparently the perc ate right through it, and you can see the length of that plume. So that's just a few examples of how long these plumes can be. And I can tell you, I know of plumes on 3rd Avenue in the Bronx that there's no record of them because of the way the disclosure laws operate under CERCLA and under New York state law, but they're there. And obviously, we haven't talked about air issues, but when you have a dry cleaner in an apartment building, there are issues about vapors going up into the building. And so there's all kinds of air permitting requirements as well. Let's see. So just a quick note here. I was mentioning to you that when the vapor intrusion started emerging in the early, there was a question about whether OSHA or the EPA or state risk-based levels should apply. And this is just a sort of a diagram of where the jurisdiction usually falls out on. But the problem is that the PELs that OSHA uses are antiquated. They're from the 1970s. So if OSHA numbers were being used, and I've had this on a couple of sites where the seller was trying to argue there was no vapor problem because the numbers were below the PELs. But as you can see, based on what risk standards you're using, the risk-based numbers are well below the PELs. And so it's pretty well established. EPA and their guidance document, not the most recent one, the one before, basically put this issue to bed that when you're dealing with vapors coming up from out of the ground, for purposes of cleanup, It's their risk-based numbers that are being used, not the PELs. I think, Mike, that might be the last slide I have. Yes.
Yep. All right. All right. Thank you, Larry. That was very informative. And I'm going to follow up with a couple of questions that I hope will add a little bit more information in some areas that I've experienced over the last couple of years. I review a lot of phase one environmental site assessments and come up with a lot of the issues that you talked about. But one of the things that I encounter a lot of times is the reports sometimes conclude that the dry cleaner was historical. And the reason they say it's not a wreck was because there was no recorded violations or no reported spills. In your mind, is that sufficient information to say that the dry cleaner was not a recognized environmental condition?
No, because particularly if it's an older dry cleaner, a dry cleaner operated before 1980, or even in the early 80s, there were really no reporting requirements in those days. So the fact that there's no violations doesn't mean that there wasn't an issue. What you need to look at was what were the practices. And in the absence of any proof that there were releases, you can't prove a negative. So you can't prove that there was no release, but you know that based on professional experience, based on studies that we have known that date back to the early 90s, that there is a high percentage of dry cleaners that have had releases. And we know where they were. They're usually at the equipment where it's, or it's at where the waste drums are. And oftentimes it's in the backyard where they, you have to look at do you have information about how the waste was handled? How the raw product delivered? Was it by truck? Was it, you have to evaluate all this stuff. Did they have a solvent grade floor coating? I mean, you have to look at the risk factors. And if you can't answer those questions, the odds are that dry cleaner warrants further investigation.
Thank you. Yeah, and my experience, we've done 500 to 600 dry cleaners that have used PERC. Maybe not all of them use PERC. Some of them use Stoddard solvent. But the ones that use PERC, we have about a 99% detection rate, actually even a little bit higher, detection rate of a release. The study you quoted reported 75%. It doesn't matter which number you take, that's still a high percentage. Absolutely.
You know what we're also finding is that we're starting to see now that most states are asking in their remedial programs to sample for PFAS, we're starting to find PFAS showing up at dry cleaner sites, which makes sense because it's coming off the clothing. And I actually had a site, I had the 0.01%, Mike, recently, where there was no PERC at the site, but there was PFAS.
Yeah. And that's a wet laundry, and that could be a wet laundry issue and not even a dry cleaning laundry issue.
Yes.
Very good point. Thank you. The other thing, in recent years, a lot of the states have, not a lot of the states, several states have adopted either a state lead or a state funded dry cleaner program, a very specific program for dry cleaners. And what I'm seeing in the reports that just because a site is participating in the dry cleaner program, does that mean the liability is gone? It's not a wreck?
No, technically under the definition, it's a wreck. What's the liability? Well, you're sitting there waiting 10 years for the state to come around to investigate and remediate. Well, while that's happening, the contamination is either migrating off-site, potentially, which could potentially put, if it's a residential community, could potentially put them at risk. So there's potential toxic tort claims, plus people coming to your property. The other thing, in addition to the dry cleaner funds, there are some states some states allow towns or cities to write off the groundwater so that it doesn't exist in the regulatory standpoint. And I've seen some lawyers try to argue with the consultants that because there's no enforcement about groundwater contamination, that this is now a de minimis condition. So they're identifying a former on-site dry cleaner as a de minimis condition because the definition of de minimis is that if this information was brought to the attention of the regulator, they would not result in enforcement action. But I talked to this with Julie Kilgore and other people on the chair in the task force, because I was concerned about this. And the minimis, that was not the reason why that definition was put into the standard. It was for the oil stains on the parking lot, you know, those kinds of things. There is still a wreck. And the problem with that is, what if, you know, the city management or the state changes its policy? Now you're suddenly exposed. So that to me is an incorrect interpretation. It's being used to facilitate funding. The concern in one case was that would kill the funding for this affordable housing project. But do you really want to? And the idea was they were putting in a vapor barrier anyway, but you know, that was not the right interpretation. So if you believe as a environmental professional that there is a likelihood of a release, that it should be identified as a wreck. You also want to protect yourself from liability and your insurance policy.
Yeah, I have one I'm reviewing today where the original phase 1 and the closure was done in 2009, which kind of predates the vapor intrusion buzz. And now the consultant is saying that even though there's been a closure issue, there's a wreck, and that's the right conclusion, because the original closure did not consider the vapor exposure pathway. And so that liability, even though the original closure from the state doesn't eliminate that liability still remains.
We have made it in our last 2 revisions at ASTM. We really focused a lot on HREC and CREC, right? And yes. Part of the process is when you have a site that was closed in the past, you have to now look and see, would it still be closed now? And oftentimes there's new information. I mean, in New York, we had 421 sites reopened because they had not evaluated the vapor pathway. And other states, they don't have the same kind of formalized approach, but they're doing that as well. So you have to look at, why was this site closed? And did they evaluate the pathways and the standards change? And oftentimes, you know, once it's closed, it's out of mind. And the other problem is you also want to do this when you're changing use. So it may have been closed for commercial, but now you're going residential, it may no longer be appropriately closed.
The other thing that I think that most rules that are out there have what I call a substantial change in conditions. And I know it's hard for people to say, well, this vapor issue, if it wasn't an issue in 2009, why is it an issue in 2023? And I said, well, because that triggers a substantial change in conditions. And they say, well, the conditions of the site. And I said, no, it's the conditions that's associate with the regulatory background. I mean, I think those are
reopeners. You have to and again, look at the no further action letter, and they're usually conditional. You know, yes. Conditions, and if you have a change in the cleanup standard or a change in use, that the protections afforded by that document may no longer be applicable.
That's right. So the last thing before we get into the attendees' questions, you talked a little bit about the innocent owner and purchaser, and really, if you could elaborate, the bona fide prospective purchaser, there are some liability protections if someone qualifies, correct, for that, but it requires the proper amount of due diligence. And also there are following conditions that you have to meet, correct?
Yes, I oftentimes use the Seinfeld episode about the car rental. You remember that episode where Jerry came to the counter and the car wasn't available. And he said, you know, you're good at making reservations, but you're not good at keeping them. And the keeping is the important part. So it's relatively easy to qualify for the defense. You have to show that you didn't have a relationship with the responsible party. All the disposals occurred before you took title, and you did all appropriate inquiry. And all the appropriate inquiry is you identify there's a release. Once you take title, you have to exercise appropriate care. And that's the part where you could lose your liability protection. And if you don't evaluate the vapor pathway properly, and it turns out there's a problem, you're probably going to lose your defense. Yeah. So it's a good thing to, you know, and a lot of times in some states like Michigan has a great due care plan where you actually put together a due care plan. So usually we try to get some sort of system in place so that they periodically, because even if you have a system in place, if there's a malfunction, you can still, so that the defense is conditional. You just can't say I'm done. There's on, and the other thing is, you know, if the consultant has recommendations in their phase one and the borrower, the owner, the client doesn't follow those recommendations, there have been court decisions that have held that the failure to comply or follow the recommendations is a sign of lack of appropriate care. And then suddenly now the client is now liable. So one of the effects of that case law is sometimes I try to put recommendations in the side letter, because AI and ASTM does not require recommendations. The consultant has to make conclusions and opinions, but they're not required to make recommendations. And that's where you can run into trouble as a client, property owner, bank. Banks usually want recommendations. I try to put those in the side letter unless we have an agreement with the owner, my client, that, hey, you know, these recommendations you got to follow.
All right. Thank you, Larry. Scott, I'm going to turn it back over to you and let you lead us in some of the participant questions.
All right, great. Good job, guys. All right, let's move on next to answering the questions from the audience. There's quite a bit here. If we'll try to answer as many as we can in the remaining amount of time. The good news is both Mike and Larry have agreed to answer any of the questions we do not address during the webinar. So let me just get the first one. I'll start this. Can you explain the common law issue in a bit more detail?
I think that question occurred before I got to that slide. But again, the common law was, you know, negligence, nuisance, trespass, those kinds of old-fashioned remedies that you can be liable for. Now, those are not strict liability. Those you have to actually, you know, do something. But those are also potential liabilities that are not eliminated by the no further action letter. Those no further action letters are limited to the statutory protections, liability, I mean.
Okay. Mike, in your experience, would you say most plumes are confined to the areas beneath the cleaners? Did they ever, do most of them spread out beyond the property boundaries, or they can contain beneath the cleaner itself?
So that's really a geologic question, but in my experiences, the examples that Larry showed are not uncommon where they extend very far off the properties. But again, in areas where we have very little groundwater transport, they're very small and they can be very well confined to the property. And even over very short distances. Dallas, Texas is an area where we have a lot of shale and limestone areas, but they also have some sandy areas. And so some areas, the plumes are very small, but I would say that in general, I would say the plume extends well beyond the dry cleaner space.
We are dealing with sinkers, so to speak, right? So we got lots of sand, it's going to sink till it hits. But the issue is, are there any preferred pathways or conduits? That's the thing that, I mean, I've had sites in Phoenix where there's been plumes. So I'm not suggesting that every site has a mile-long plume, but I'm just suggesting that those illustrations were to show you that dry cleaners pose a significant risk. They should not be underestimated in terms of their risk. As I said, EPA said that's the #1 type of site now, being the reason that sites are being added to the Superfund list. So you're not going to have mile-long plumes at every site, but you may have plumes that do extend beyond the site. It's not. I've seen it more frequently than not.
Okay, two-part question. Do closed-loop dry cleaner machines present less risk of a release than other type of machines? And two, does the fact that a commercial unit is very small here as a valid rationale for assuming that there was no space for a dry cleaning machine? So what's the square footage of typically needed for a machine?
So the answer to the first one would be yes, because the amount of waste they generate is less. But I've seen big plumes associated with closed loop dry to dry machines that are equal in magnitude as those. It has to do with how they handle the waste once it leaves the machine. And then the second answer is there a tenant space that's so small that it would not actually have a machine in it? I would say that if the space is less than 100 square feet, that's an easy answer. No, there's no dry cleaning machine in it. But I've seen tenant spaces that are 500 square feet and had a very small dry cleaning machine in it. And even worse than that is the old washaterias that had the coin operated machine. And these are little bitty machines, but so that's a very hard question to answer.
So Mike, I've also seen a couple sites in New Jersey where the only way that the site was contaminated by the vapors coming out of the pipe, on the top of the building. And the moment it hit the air, it condensed, and you could see like all this cracked asphalt underneath the pipe.
Right.
And over time, that created issues.
Yes, absolutely.
Next question. Is there lender liability potential if after a phase 1, the lender chooses insurance instead of a phase 2 and during the loan term, a tenant, upper floor resident discovers health issues due to chlorinated carcinogens?
Generally, no. The lender is not an owner and it's not an operator generally, right? And the EPA rule has clearly stated that actions taken by a lender during a term of its loan, such as, the usual things that lenders do to monitor their loans, would not create liability under CERCLA. Now, under common law, again, that you'd have to show that somehow the bank was negligent. And I just don't see, it just doesn't seem, unless there's a special situation, I don't see the lender being liable. The only way the lender could conceivably be liable is if the responsible party was even in that case, responsible party asking for some financing to fix a problem. But even in that situation, lenders have been found not to be liable generally. So I don't think that's now, obviously, lenders are also concerned about the value of their collateral and the ability to borrow to pay back their loan. But usually toxic tort liability is generally not something that a lender needs to be concerned about.
Okay, we'll do a couple more questions here. In practice, are you seeing environmental professionals using E2600-15 as part of their phase 1 ESA? And if not, how are they typically addressing subsurface vapor migration encroachment?
So my experience is that's kind of an evolving area. I'm seeing it more and more today than I did back when the VEC came out. And I'm having to ask fewer times for that. So I'm just going to say that's one of those things that I think over time people are becoming more and more knowledgeable about, and so you're seeing it being addressed. Is it addressed appropriately? That's a whole different question, and my answer is there's still a long way to go before someone's fully implementing the E2600 standard.
And remember, that's really about the site. The target site is not doesn't have a dry cleaner. This question is, are there molecules of PERC coming onto the target property? And that again is something you're going to have to evaluate, as Mike said, the geology, preferred pathways. You know, if it's right next door, you know, I have a deal this week, in fact, where there's a property right next door. The recent one consultant said it was a wreck. The borrower went out and got another consultant. He said it was not a wreck. So we're now working that out. But and you know, they don't want to have a wreck because they were trying to go through environmental review for funding for affordable housing. So, it's again, you're talking about, is my property affected by an offsite dry cleaner? That's, I think, it's not that there's a dry cleaner on the site. The VEC is not as important there.
Okay, in your experience, does that mean that all investigations derive waste from a property with a dry cleaner should be disposed of as hazardous waste? Or is it only if solvents on the F list are detected? Or if only if the concentrations are in excess of remediation objective?
So investigation derived waste have special exemptions in RCRA, and so I would, and we don't have time to go through that and properly answer it, but I would strongly suggest that if someone's dealing with investigation derived waste, they get with their disposal company, because they will know the answer to that question.
Okay, this will be the last one. Does New York have MS4? Mike mentioned contamination was occurring. Why was there contamination with a sanitary sewer?
So the MS4, I'm going to assume that they do. The dry cleaners have several discharges, a separator water, which comes off the back of the machine, was very commonly poured down the drain. As much as I don't want to say this, but they also took their waste and they poured their waste down the drain.
If they didn't have a backyard.
Yeah, and the backyard, in the dumpster. And those things occurred, and unfortunately some of the construction materials like the ABS pipe and the PVC pipe are very susceptible to damage with these discharges, and like Larry said, even the ones that use the asphalt seals in them, that deteriorates the seals. So,
and the thing is, you also got to look at, I mean, it's important to know, how is this property sewered at the time the dry cleaner was there? So they may have had a septic system, right? And maybe right now it's no longer a dry cleaner and it's sewered. Okay, but what was it like when the dry cleaner was there? The other area that's a common source of contamination are dry wells. So I have a site that's been, we cleaned up, then we got reopened, where they would dump stuff in the dumpster. When it rains, the stuff comes out of the dumpster and goes into the dry wells. And the dry wells are bare dirt. So you got to look at all those factors to see whether, you know, there's been a problem with the way the underground injection well program is enforced. And there's no way that some septic system should have ever been allowed for commercial properties. It just, I mean, when you have a gas station or a dry cleaner, that just shouldn't happen. But we have a lot of those. And then we have dry wells. And dry wells, for example, Long Island are a number one source, if not the number one source, a leading source of contamination. Because everything in the stormwater that it picks up gets into the dry well. So you have to look at the property as part of historic. You know, we know the historic research is so important, and you got to look at the property. What was it? How was, you know, what was these? Was it sewered? Sump? You have dry wells there. You got to look at it holistically to try to evaluate what is the chance that if there was a release, that it got into the environment.
All right, well, thank you, guys. Well, fortunately, that's all the time we have for today's presentation. Mike and Larry have agreed to respond to any questions that were not addressed during this webinar. Once they are answered, we will send out notice, let the audience know. To read more about dry cleaning, go ahead.
Yeah, if you want to contact me, you can email me instead of phoning.
Yeah, well, we'll show that information that's
Okay.
coming up.
Okay.
So to read more about dry cleaning, commercial real estate, emerging contaminants, or environmental and property assessments, please visit Aris Info Hub on arisinfo.com, which contains curated articles, podcasts, and webinars on many topics. A reminder that this webinar has been recorded and will be posted on the Aris website in the next day or so. We look forward to hosting you at our next Aris webinar, which is Tuesday, April 11th, entitled Integrating Climate Risk Assessment with Environmental Due Diligence in Canada. Then on Wednesday, May 17th, we will host a virtual demo of our new report authoring platform called Scriva. The links for both webinars are in the chat, but also can be found on our homepage at arisinfo.com. We can also show the contact information for these guys. That'd be great. Then look forward to announcement from us about part 3 of dry cleaning series. On behalf of Aris and our audience community, I'd like to give a big thank you to our presenters, Mike and Larry, for their knowledge, experience, and their time they shared with us today. If you wish to get in touch with either of them, it's on the screen. Finally, to our audience, we want to thank you for your abundant attention during this past hour. Please enjoy the rest of your day. This now concludes the webinar. Thank you.
Thank you.